today's webinar is particularly directed towards lawyers, and we always are happy and welcoming of the housing counselors to sit in. I think it will be a useful tool and a useful session for housing counselors, but just as a reminder, this session is geared toward lawyers doing foreclosure prevention work. So I just want to say thank you so much for Lauren Breen with SUNY Buffalo Law School and Matthew Parham with the Western New York Law Center. They have agreed to provide this training. It's not directly related to the work that we all do, but we frequently encounter more than just foreclosure issues when our homeowners walk in the door, of course. And the Fair Credit Reporting Act, I think, is an important issue that people should be aware of. So since I'm running these, I figured it would be a good session to provide. So hopefully it's as helpful as it is to you as it is to me. So with that, Lauren and Matthew, take it away. Thank you.
Thank you, Becky, and thank you, Michelle. Hello from Buffalo, everyone. My name is Lauren Breen. I'm a clinical professor here at SUNY Buffalo Law School, and I have Matthew Parham, who is the senior consumer attorney at the Western New York Law Center. I'm just going to say a couple of words about Matthew because we are so very lucky that we have him here in Buffalo. He's been working with the Western New York Law Center for 3 years, but I think on a full-time basis, I just got a message that on LinkedIn that you have a 2-year anniversary, Matthew. So congratulations on that. Matthew is the expert consumer attorney for the Buffalo Claro Project, civil legal advice and resource office. And as a matter of fact, he's just come from city court this morning. And through that project, he assists pro se consumer debtors fighting consumer cases. So he really has a background in this area that runs far deeper than my background, and this is the area in which he focuses. We were lucky to get him from the law firm of Sullivan and Cromwell back in Buffalo, I think about 4 years ago. So he, prior to going to the Western New York Law Center, he had his own law firm that focused in the area of consumer law. So today, we're going to cover 4 areas with you relating to the Fair Credit Reporting Act, or FCRA, as it's referred to. Matthew is going to do the, I guess, the meat of the presentation in terms of the FCRA overview, but I'm going to start with just a little bit of information about, why this statute came to be, and why it's important not just for legal services attorneys, but I would say also for the housing counselors in the audience. FCRA was passed essentially to address abuses in the consumer reporting industry. I'm told I need to advance on this. It was passed in 1971, but over the years it has been made stronger and stronger. It's kind of interesting, the first major credit reporting agency, Retail Credit, was started in 1899, and I know that it was the precursor CRAs, I'm not sure which one, but it really, by the 1960s, there were numerous abuses in terms of consumer investigations and consumer reports. And consumer investigation reports were found to be reporting very personal information about people, including lifestyle information, sexual orientation, marital status, drinking habits, and cleanliness, in addition to your credit history. So FCRA was enacted in direct response to really violations of privacy for citizens. So I'm not going to get into, we have a number of slides. Matthew's going to go through this in a little bit more detail, but these are basically, for your information, the major components of FCRA. But I think the right to privacy is one of the biggest ones that we'll be addressing today. So for legal services attorneys and the housing counselors in the audience today, why should we care about FCRA? If we're worried about fighting foreclosures, how does fair credit reporting come into our practice? And I'm sure if everybody weren't on listening mode, there would be 50 different answers of why this is important. But I'm just going to touch on in the materials, I think from page 16 to 19, there's the Federal Trade Commission and DEMOS. There's excerpts from testimony and research reports that show really the abuses or the harm that the inaccuracies, the errors in these reports are inflicting upon our client population. So I think the FTC report says 1 in 5 people have major errors on their credit reports. And so for attorneys that are helping people to remain in their homes, when you're fighting foreclosures, I know you're looking for loan modifications. In Buffalo, I know when I was at the Western New York Law Center and I supervised a team of attorneys doing this work, people who were trying to get reemployed, prospective employers were looking at credit reports in terms of informing their decision whether or not to hire someone. So lots of different reasons why we as legal services providers and housing counselors want to be sure that our clients' credit reports are accurate. So, all right, so with that, I'm going to move on to Matthew.
Thank you, Lauren. So I'm going to cover the overview of the statute. I've been given the meat of the presentation, but not the motivation, which Lauren just provided. So I'm going to do basically 3 things. First, I'm going to help situate us. Where do you go if you want to find the FCRA and the law related to it? And then talk about what it covers, what's the subject matter of the statute. We usually think of it as credit reports, but it actually is broader than just addressing what we think of as a credit report. And then talk about some of the substantive rights that it creates for consumers. So in terms of situating, first of all, the FCRA is part of a broader package of federal consumer protection legislation. It's, when it was enacted in 1970, it was tacked onto an existing act, the Consumer Credit Protection Act. And that's basically what Congress has done every time it's passed a new package of federal consumer protection legislation. Of finance is sort of tacked onto this act. So it's really part of a broader package, and sometimes there are references to other parts of the Consumer Credit Protection Act within various statutes to where you have to look somewhere else in the CCPA to find out how you interpret some provision. The other parts of the CCPA, generally there's truth in lending, which was the original Consumer Credit Protection Act, was mostly about truth in lending, and a few other things, limitations on wage garnishment being probably the most important one for legal services attorneys, although you don't really ever have to look at the federal limitations on wage garnishment since New York State has more protective ones now. But that's what Congress first passed in 1968, was mostly truth in lending, limitations on wage garnishment, and then in 1970 the FCRA was tacked onto this, and since then Congress added equal credit opportunity, which protects against discrimination in credit, Fair Debt Collection Practices, Electronic Funds Transfer Act, which governs electronic funds transfers, as you might imagine, and then the Credit Repair Organizations Act, which addresses companies that sell credit repair services. And if we had more time, we'd talk about that because it's very closely related to the FCRA, but unfortunately we don't have enough time to cover an entirely different act. But so this is the Consumer Credit Protection Act. It's 15 U.S.C. Section 1601 on, and then within that is the FCRA. So the FCRA starts at 1681. This slide shows sort of a list of the major amendments. But in 2003, there was a really major, not really overhaul, but addition to the FCRA that as it had existed since the 70s, which was called FACTA, which is the Fair and Accurate Credit Transactions Act. And FACTA added most of what are today the identity theft protections in the FCRA, including, this was thought of as an identity theft protection, the right to get annual free credit reports from the nationwide consumer reporting agencies was part of that, the idea being that if people annually review the report, they're more likely to detect instances of identity theft. There is a system of regulations that implement some of the provisions of the FCRA, which is Reg B, and this is where it is in the Code of Federal Regulations, Part 10 or Chapter 1022. These days, it's the Consumer Financial Protection Bureau that has the rulemaking authority received from the FTC for most things under the FCRA. There's some things we'll talk about later that banking regulators have authority for. So that's getting situated. Now let's talk about the subject matter of the Act. The Act basically addresses it's all about consumer reports, which are defined in the Act. We think of it as credit reports. It's actually defined in a way that's much more broad than credit reports, but most of what you'll use it for in practice is credit reports. And it regulates, basically, it's aimed to regulate everything having to do with credit reports. So the specific constituencies are those who publish them, and those who provide the information that goes into them, and those who access them are each separately regulated. This is sort of out of place here. So the people who are regulated are defined as people. So that's any entity, basically, and the people who are protected under it are consumers, and that's just humans. And here's the most important definition in the Act, which is what is a consumer report. So these are the things that we think of as being a credit report, but it's actually much broader. So the Act defines a consumer report as anything that's in writing, oral, or any other medium of communication of information that has to do with creditworthiness, standing, or capacity, but also things that are not credit-related, such as character, reputation, personal characteristics, or mode of living. So when Lauren mentioned a minute ago that back in the 60s, consumer reports would have a lot of information about, say, sexual orientation and whatnot. That's what that definition is aiming at. When there's, there can be sort of background check reports that are covered by the FCRA that are not what you think of as the typical credit report that would have criminal information and other things that are not, strictly speaking, credit related. But so the important limitation, though, is that, because so far the definition basically could cover any communication about a person. The important limitation is that it's a communication that is intended, or I should say expected to be used in whole or in part for the purpose of evaluating basically whether to lend or issue or underwrite insurance for the consumer, hire the consumer for a job, or there's any other authorized purpose, which we'll talk about what the other purposes are, but they're basically government licensing and benefits are the most common ones you'll see. But it's primarily consumer credit or insurance or hiring for a job. If the purpose of the communication is to inform someone's decision about whether to hire, loan, or sell insurance to somebody, then that's sort of what determines whether it's considered a consumer report. And then in sort of a circular fashion, the consumer reporting agencies are defined as any person, so that could be any type of entity at all, that for monetary fees or on a nonprofit basis regularly, in whole or in part, puts together these type of reports and provides them to third parties in interstate commerce. So this is certainly written to include what we think of as the credit bureaus and credit reports, because they sell compilations of information about credit background and that sort of thing. But it's written to be much broader, so it includes, for example, in the materials, there's I guess maybe a press release from the FTC about an action it took about a company that was giving basically oral credit reports, where people would go to a grocery store, consumers go to a grocery store to cash a check. The grocery store would call this company and tell them who the consumer is, and that they would get basically an oral credit report from the company as to whether the check was likely to bounce. So that's an example of a covered type of entity, a covered type of report that's not what we think of as a traditional credit report. So here's sort of a broader list of what can be covered. There's what we think of as the traditional credit bureaus. The big three nationwide ones are Experian, TransUnion, and Equifax. One type of credit or consumer reporting agency that I see a lot of complaints about is companies that banks order reports from, which look like a lot like credit reports, but they have overdraft history on them reported by banks, and banks look at these and decide whether to let a consumer open a checking account. And then there's other sort of specialized types of companies that do background checks, screen tenants, and that sort of thing, that are all considered consumer reporting agencies and covered by the FCRA. Oh, this is really not in the order I thought it was in. So other definitions in the Act, these are the other constituencies. So when we talk about the companies that provide information that goes into a report, the term that the Act uses for those companies is furnishers. They're the furnishers of information. And that usually is going to mean a creditor that is already, has an outstanding or existing account with the consumer that's reporting information about it. But it could be other types of company that provide information to the CRAs. And then users is the term used in the Act for anybody who obtains a consumer report. So usually that's going to be either an insurance company, prospective employer, or prospective creditor that's reviewing a consumer for an application for employment or a loan or insurance. But it could be, it could be anybody else who, with a permissible purpose, has ordered a report. And then the Act also uses the term reseller, and I'm not really going to talk about resellers because a reseller is just a type of CRA that obtains its information from other CRAs. So it's just a CRA. There are some, not worth mentioning, sort of specific reseller-related provisions in the FCRA, but not worth mentioning. So, on to substance, consumer rights under the FCRA. So if you look at the original legislative history of the Act, the sponsors basically articulated three purposes. The design or the intention of the Act was to promote accuracy, privacy, and currency of information in these reports. And that was really based on a lot of the testimony that Congress had heard in the prior years about what the problems were people were having with their reports, that they contained inaccurate information. And obviously that's still something we're dealing with, because 1 in 5 apparently still do. But imagine how bad it was in the 60s. Currency was a problem because many consumers, and this was remarked on in the legislative history, were being denied credit based on things that had happened decades past that was not any longer really truly relevant to the person's creditworthiness. And then privacy. Congress wanted to limit access only to people with permissible purposes so that essentially you wouldn't be stalked or otherwise have your confidential information compromised when people ordered your report without a purpose, permissible purpose. So I'm going to go through each of these one by one as to how the Act tries to achieve those goals. And most of the Act textually is really aimed towards the accuracy purpose of this. I suppose because it's the hardest one to deal with, obviously. It's not completely been dealt with now, but basically, so how does the Act attempt to achieve accuracy of information in reports? It basically does three things. It imposes an affirmative background obligation of accuracy on the CRAs and furnishers. It then requires that the consumer be notified at various points when there might be negative information in a report, and gives the consumer the right to obtain a copy. And then it provides for a dispute mechanism. So to drill down on those a little bit, the affirmative obligation in the Act, there's separate obligations on the CRAs and the furnishers. CRAs, consumer reporting agencies, are always required to maintain reasonable procedures in place aimed at ensuring maximum possible accuracy of the reports. And the furnishers are prohibited from reporting information they know is false or should know is false, and affirmatively required to correct information that they learn is false. Generally, there's no private right of action against furnishers for failing in that obligation. There's only the right for administrative action to be taken. In order to actually sue a furnisher, you have to go through a dispute process and notify them of the inaccuracy and have them decline to correct it. So those are the background obligations. The CRAs have to have procedures. The furnishers are prohibited from reporting false information or information they should know is false and required to correct things. Then there are various points at which a consumer will be notified when negative information might be in a report. And basically, that is when ad action is taken, which I think I just saw the definition of that somewhere, sort of out of place. And I'm not going to go through the definition because it's really kind of intuitive. This is where it is in the Act if you want to specifically look at it. But it's very intuitive in that basically if you are denied credit, have credit that exists revoked, or are offered credit on terms that are less than the best otherwise have been available to someone with perfect credit rating, that was an adverse action. If it was taken in reliance on information in a report, then that was an adverse action and you're entitled to a written adverse action notice. And the idea is that when a consumer gets this notice, they will then be on notice that they might want to order a copy of the report and look at it and see if that negative information is correct or not. The consumer has a right to get a free credit report annually, but also any time there has been an adverse action. Even if it's been less than a year since the last free report, you have a right to a new free report if you get an adverse action notice. So at that point, if the consumer reviews the report, gets their free report, reviews it, and finds inaccurate information, there's a right to dispute the inaccurate information. which is a whole process that I believe Lauren's going to be talking about in a minute. But basically, if you dispute it in writing, then the CRA has to reinvestigate, and part of the reinvestigation has to be forwarding it to the furnisher, which then has to either affirm or deny the correctness of the information. And if they don't respond at all, then it'll just be deleted from the report. And that's it. So that's how the Act aims to achieve accuracy. It's actually a much more involved mechanism than the means by which it aims to achieve the other goals. So privacy, basically, other than a few minor sort of secondary provisions in the Act, such as being able to keep yourself off of, having the right to exclude yourself from lists that the CRAs sell of unsolicited, for companies giving unsolicited credit offers. The main way by which the Act aims to achieve privacy is by limiting access. And basically, access to reports, the only users who are allowed to order a report on somebody are users that have a proper purpose. It has to be one of a number of enumerated purposes. And then the CRAs are required to have procedures in place to limit access just to those people. So in practice, what happens is anytime a user wants to order a report, they have to certify to the CRA that they have a purpose and what the purpose is. And it's a crime under the Act for anybody to falsely certify to a proper purpose. And there's a private right of action with statutory damages and attorney fee shifting against any user who obtains a report without a proper purpose. And here's what the purposes are, the proper purposes. And the first two are sort of not subject matter based. If there's a court order or a federally grand jury subpoena, which I've never really seen, and if the consumer just authorizes in writing someone to obtain the report, then it can be obtained. But without your permission or a court's or grand jury's prior approval, the purposes that authorize a user to order a report are that basically the consumer has applied for credit, insurance, or employment, and they're being reviewed for a possible extension of credit, insurance, or employment. A person applying for a government license or benefits, and then the government agency can order the report, or a review of an existing open account, which could be a collection account, but by a company the consumer already has an existing relationship with. This last one is a legitimate business need, which basically is designed to cover other types of anticipated contractual relationship than credit, employment, or insurance, and keeping in mind that the Act covers a much broader array of potential reports than just credit reports, but it's not intended to be. Basically, the intention of all of these provisions is that the consumer has impliedly authorized this to happen because they've applied for or sought some contractual relationship with the company pulling the report. So those are the authorized uses, and that's how the Act aims to achieve them, is by limiting access. And then the Act also finally aims to achieve currency of information, so to ensure that there's not stale negative information in reports. And basically what it does to achieve that is that it has a provision that says that negative credit information is supposed to be removed generally. There's a default provision that says it's to be removed generally within 7 years after the last activity date, other than for bankruptcy filings, which are to be removed 10 years after the filing. And that's a little bit of an oversimplification, and here's the excessively precise chart showing what the actual statutory requirements are. And let me see if my other slide is here. It's not dark. So this is really not worth memorizing at all because in practice, like really the best place to go to see what the credit bureaus actually do, if you're looking at credit reports, is that the credit bureaus all have FAQ, frequently asked questions, pages where they say exactly what they do. And they don't do any of these things because this is, while it's overly precise also, overly simplified in the sense that if the credit bureaus just tried to comply with what's on this slide, they would end up violating other provisions of the statute that are totally inconsistent with these. So they've basically decided that what they're going to do is what they say they do on their FAQ pages. And essentially that is negative credit information comes off as after the information became negative. So the last mispayment, for example, if it's a past due account, the information falls off after 7 years. Judgments fall off after 7 years after they were entered. Tax liens are 7 years after they were paid, or otherwise they stay on for 10. Bankruptcies are 10 years after filing if there's no discharge, and after discharge if there's a discharge, although for 13 it's actually 7 years after discharge. but for a Chapter 7, 10 years after discharge. And it's not on this slide. I wanted it to be, but New York has a New York state-specific. Is it? Is it somewhere else?
Yeah, I think so.
Okay. I guess I should look somewhere else for it. Well, New York has a state-specific Fair Credit Reporting Act, which for the most part doesn't add anything to the federal one, but it does in two respects. One of which is relevant to what I was just saying, which is that New York provides that if for New York resident credit reports, paid collection accounts and satisfied judgments are to be removed after 5 years, and the bureaus all comply with that. And it actually is. States are allowed to do that. The Act generally doesn't provide for preemption. There's a few specific things as to which it does, but mostly it provides that states are allowed to have more strict requirements than the federal Act. So as to paid collection accounts and satisfied judgments, they fall out for New York consumers. They fall off reports after 5 years. And the other thing the state act does is it allows for injunctive relief in a private action, which the federal act does not allow for. And I'm trying to figure out where I even end, because am I supposed to be covering this?
Yeah.
Right.
Well, I mean, to the extent that
well, let me
to.
skip it, because I wasn't planning on it.
Okay.
Okay. So those are your three basic rights: are accuracy, privacy, or confidentiality, and currency. And if your rights are violated, generally you have a private right of action. You have to bring an action within 2 years after discovery of the violation, no more than 5 years after the date of the violation. If it's a violation of, say, your dispute rights, something was wrongfully reaffirmed after being reinvestigated, then you're going to have notice of the violation when you receive the results of the dispute. And so you might be time barred on one dispute of the same information, but just can redispute it to thereby create a new right of action if the FCRA does the same thing. And then basically the remedies that you can get in a private lawsuit are similar to the remedies for other federal consumer protection laws, but Congress did go in and sort of separate out negligent violations from willful violations and only allowed statutory and punitive damages for willful violations. In practice, what this means is that, like, if you want to sue a CRA for a violation, it's willful, so you really want to give the CRA as much rope to hang itself as you can. So you want to submit a lot of disputes with a lot of information and comply with any follow-up requests for information, and just make sure they're really on notice of exactly what the dispute is and that there is one before you go sue. Because if all you have is inaccurate information, you sue just because they didn't have reasonable procedures in place to ensure it wasn't inaccurate, and you will have trouble showing more than a negligent violation. There are some things as to which there's no private right of action, and generally, as to furnishers, you can't sue the furnisher unless you've gone through the dispute process, and then you can sue for a violation of your dispute rights, specifically if the furnisher has reaffirmed information that it shouldn't have reaffirmed during the reinvestigation without truly reinvestigating it. That's the sort of thing you can sue furnishers for. So in the materials, there's some information about some recent litigation. This is what I mentioned earlier. The Telecheck company was this company that was providing oral credit reports on people, and it would be sort of hard to provide consumers all their rights with respect to an oral credit report. How do they even find out what to dispute if they don't know what the oral credit report was based on? But that was the problem with that company, that they weren't really providing consumers with their true dispute rights. And then this is an example of a case that sort of shows like how substantial the damages can be, even just for an individual. This is just one person. This other case, $3.5 million settlement, but for a company that did the same thing to thousands of people. But this was a case against Equifax, just by one consumer, where the consumer was submitted, I believe, 8 or so written disputes about the fact that her credit report had all of this other totally different person's information on it who didn't have very good credit, but it was keeping Julie Miller from getting loans, and she was being denied for things. And this was a case where the jury, I think, awarded hundreds of thousands of dollars in damages, but then millions and millions of dollars in punitive damages because of this pattern of Equifax just declining to even open an investigation, notwithstanding all of the many disputes they received, thereby showing willfulness of their violation.
Okay, thanks, Matthew. And again, we're going to be taking questions at the end of the formal presentation. So if you have questions, enter it into the appropriate field on your screen. And I think Becky will be reading the questions out at the end of the presentation. So how can a consumer correct an inaccurate credit report? We said that the FTC, their research showed that 1 out of 5 people has a material error in his or her credit report. So we want to know how we can correct these. And as legal services attorneys and housing counselors trying to help people get loan modifications or to become reemployed so that they can be a better candidate for a loan modification, how do we fix these credit reports? So in your materials, just as I advance to the next few slides, I think pages 16 to 19, most of what we're going to be discussing is listed out in further detail. So how do you know if you have an error on your credit report? You need to get a copy of your credit report and read it. So we want to advise our clients to get copies of their annual credit report. Now you can do this online. It's my understanding that online you potentially waive some of your rights, so it's a better idea to get this through the mail, to request it through the mail. Matthew?
When you order the reports online, they make you agree to arbitration in the terms and conditions, which is different from if you order it in the mail. For some reason, they could require that through the mail too.
Yeah, so it's a good idea to order it through the mail, and Matthew mentioned a few minutes ago that you can get an annual free credit report. That's from each of the 3 major consumer reporting agencies. So you can get 3 free reports each year. In addition, you're entitled to a free report if you, as Matthew mentioned, if adverse action has been taken against you. If you're unemployed and plan to look for a job within 60 days, if you're on public assistance, or if your report is inaccurate because of fraud, including identity theft. So a number of different ways to get a free report, or you can buy a report. So we've just listed some of the information here, the contact information, but more often than not, you ought to be able to, or your clients ought to be able to get a copy of a free report. And then they want to look at it and see, is everything in the report accurate? If there are mistakes, if there are errors on the credit report, okay, it's very important. You want to put your request in writing and send it certified mail. I know that that's expensive. Through the Claro project, I think we help people with some of the mailing expenses, but it's really important because you want to have a record showing that the dispute was actually sent. So you really do want to do it in writing. You want to send it by certified mail, and you want to make a copy. I know that this can be hard for our clients, but you want to make a copy of all the correspondence that you are sending. So in the Julie Miller case, I think it was numerous disputes, and every time they came back and said, no, this is accurate. And I think in that case she was trying to obtain credit to help her disabled brother. I mean, it was particularly sympathetic facts in that case. But I think Matthew and I both saw the Justin Baxter, the attorney who brought that case at the National Consumer Law Center conference a couple years ago. But he said she kept disputing it. She kept a record of everything, and I think in that case she was writing the letters herself. I don't think that she had her attorney do it. All right, so in the materials, the FTC instructions for disputes, 16 to 19. Contact the furnisher. The letter can be from an attorney. It may get more attention. Again, I don't know, Matthew, do you have any thoughts about this? Do you think that it's better to come from the consumer rather than an attorney in terms of if you're thinking that there's going to be litigation down the road?
Yes.
Yes, you think it's better to come from the consumer. So I just want to point out that there may be different strategies here. So the most important thing, though, is to keep a record. So you want to include your identifying information and tell about how you were harmed by the error. So in the Julie Miller case, her disabled brother, I think he was developmentally disabled. She was trying to help him get a loan. I forget what it was for, but she explained that in her disputes. You want to send a copy to each of the big 3 consumer reporting agencies. So Send it certified mail, as we said before, keep copies. And then when the CRA receives your dispute, okay, they have to, there has to be an investigation. So they're going to either delete the disputed information or conduct a reinvestigation. You know, what happened here? Is it accurate or not? This is a sample dispute letter. It actually is, I added some information. I think this was based actually, Matthew, on the letter that you have in the Claro form system. So no, it's a combination. So this is a little bit stronger, I think, than the sample at the FTC site. So so take a look at that. But I think that's a pretty good example of a dispute letter. You want to include your full name. One of the things that we saw, I think multiple times at the Claro Center, is that we had a father and son, junior and senior. So it stands to reason that there could be mistakes, you know, if you have the same name within a family. So you want to include the full name of the consumer with the junior or senior added to it, current address, previous addresses, date of birth, telephone number, social security number, your spouse's name, current employment information. You want everything that you can give so that there's no question about the person that the information is being reported on. But you also want to, you know, when you look at one of these reports, they contain a lot of information, and you want to be very specific about which item you're disputing. So include a copy of the credit report. I know that when I did these at Claro, I circled the disputed item. I think if I had a highlighter, I highlighted it for the consumer. And tell them why you are disputing this. So on the slide here it says, this account does not belong to me. I know we have the father and son situations. We say, this is my father's debt. This is not my debt. So, but you want to include as much proof as you can, you know, making your case that this is an error on the consumer's report. If you think that you're a victim of fraud or identity theft, you really have to indicate this in your letter, and you want to include a police report and an identity theft affidavit. You want to request in your letter that the credit reporting agency, the consumer reporting agency, delete or correct the information. So you just want to be as specific as possible, even if it feels like, you know, you don't need this much information. They get the volume. The volume that we're talking about here is it's just unimaginable. So it's really important, and I think in the Julie Miller case, that was one of the defenses that they had. Oh, we've got, so, you know, the volume is incredible here, and the name Julie Miller is not altogether a rare name. So you want to be sure that you are being as thorough as possible when you dispute the inaccuracy on the credit report. You want a copy of your driver's license and a recent utility bill to prove that your current address. You should also send a copy of your dispute letter to the creditors or other furnishers of the disputed information. So you know this, and I would say send it all certified mail if you can. So keep copies of everything. And when you get that receipt back, when you send it certified mail, be sure that you keep that as well. Matthew, I don't know if we have enough time really to talk about this in terms of the time frames for the reinvestigation. And some of the things I just want to, I do have more slides included in the presentation and a little bit of additional information included in the materials than we're able to cover today, but that's just so when you go back, you can use, when you have a question in the future after the presentation, you can go back and use these, both the PowerPoint and the materials as a reference point. So, so these are some of the time frames that apply to this, but you know, if you don't get a satisfactory response, and I think, again, in the Julie Miller case, dispute, again, you know, don't be afraid to continue to dispute. So we've got more information here about some of the time frames. If your investigation, again, is unsatisfactory, if the investigation does not produce a satisfactory result, you can ask for a statement of the dispute to be included in your consumer's file and in future reports. Now, if you want additional statements, and I think for the past, if you do get a satisfactory response, you can go back, I think, 6 months for if any reports had that that error. And I don't think there's a fee associated with that, but if you're successful, yeah. But if you're unsuccessful and you want the statement, your dispute statement to be included, there probably is going to be a fee associated with it. Okay, so I'm going to turn it back to Matthew for a little bit of information about identity theft.
So I'm going to try to be very brief so we have time for questions. But so this is, identity theft is sort of a separate thing from the other rights that you have under the FCRA because of the fact that it was all the identity theft rights were sort of tacked on in the 2003 amendments. And Congress really provided like much more robust rights to somebody who's been a victim of identity theft to have information removed from a report than just somebody who has a dispute that's based on something other than identity theft, as well as some other protections. So the primary protections are these three. There's a process to assert a claim of identity theft by providing an identity theft report or identity theft affidavit, which is a form promulgated by the Federal Trade Commission that the consumer can fill out and sign under penalty of perjury, and as long as they've provided all the information called for by the form, and under some circumstances may have to, should at least try to obtain a police report or other law enforcement report and attach it, but if unable to do so, can just say that. As long as that is completed and provided to the CRA then has some obligations with respect to the identity theft accounts, the accounts created by identity theft. And that's one of the main protections created by the 2003 amendments. And then there's also the right to have a fraud alert placed on an account, or I should say on a consumer's report, which is designed to prevent identity theft. And then these, what are called the red flag rules, which are sort of something that the consumer won't even necessarily know about, but they're another initiative designed to prevent identity theft and fraud. So the identity theft reports, basically, like I said, as long as the consumer gets the form or a police report of identity theft, provides all the information, which is basically what the account is, whether the consumer received the benefit of the account at all, and whether the consumer knows who stole their identity and opened the account, and if so, identifies that person. Basically, that's what I recall being on the form. As long as the consumer fills it out, puts everything on there, sends it under penalty of perjury, provides it to the CRA. The CRA has the obligation to, quote-unquote, block the entire trade line associated with the account, which means it has to be immediately deleted without, immediately upon receipt. It has to be deleted from the reports so that it's distinct from the dispute process where there's a 30 to 45-day investigatory period where it's provided to the furnisher for them to respond. If it's identity theft, then it has to be immediately blocked. And the furnisher then also has obligations to not, the furnisher is prohibited from selling the account to another company or from placing it with a collection agency or law firm for collection, and is prohibited from re-reporting the information unless the furnisher can say that it has quote-unquote knowledge, has actual knowledge that the identity theft report is incorrect, which is a much higher burden than just sort of reasonable belief or something like that. It has to be actual knowledge that the information actually, or that the account actually was opened by the consumer. In practice, you don't see too much re-reporting because of the high burden there, but I don't think this has really been tested in court what the sort of level of mens rea would have to be on the part of the furnisher before it'd be allowed to re-report information, but it's intended to be a high burden. Those are the primary benefits of the identity theft report. Basically, the consumer can get the account immediately deleted. There's a very high burden to have it show up again or be collected on again. Fraud alerts, the 2003 amendments created this process where any consumer, whether or not they have, been specifically victimized by an identity thief, any consumer has the right to contact any one of the three credit bureaus, three major nationwide credit bureaus, and place a fraud alert on their report, which will then be placed by that bureau on the other two bureaus' reports, so all the reports will have the fraud alert for 90 days, and any consumer who's done the identity theft affidavit can extend the alert to up to 7 years. And during the period that is in place, the primary protection of having the fraud alert is that any creditor that pulls a consumer's report to review an account application is then required to contact the consumer at the phone number provided in obtaining the fraud alert, so the phone number that is on file with the credit bureau, before opening the account. So this is designed to protect against potential identity theft. The red flag rules are sort of something that's in the background, but it was also added by the 2003 amendments. And basically what the red flag rules are is that the amendments required the banking regulators to put rules in place that require their constituent banks to have procedures designed to detect fraud and identity theft. So I know I've been the beneficiary of this many times when people attempted to buy plane tickets from Ghana and other places in Africa to the United States using my credit card. The banks just discover these things due to whatever procedures they have, and I don't know what they are or have to know because they just call me. But that's why that started happening more since 2003 is because of those rules. There were some other various privacy-related 2003 amendments, again designed to prevent identity theft, such as requiring that the CRAs not put entire account numbers on reports, so that if someone, you don't shred your report and someone gets a hold of it, they won't know all your account numbers, giving consumers the right to have their Social Security number truncated on reports. There's this notification of address discrepancy thing that basically says if someone's applying for credit using an address other than the ones that are on file with the CRA, then they're going to be notified of the discrepancy. The creditor that the person's applying for credit with is going to be notified of the discrepancy. So that there's sort of miscellaneous stuff, additional stuff. But those are the main ways that the 2003 amendments aim to prevent identity theft.
Thank you, Matthew. I just wanted to draw everybody's attention to, we didn't have a slide on this, but I included it in the materials on page 23. It's a page, it's a printout from the Social Security Administration's website. And I include it because last spring I was on a listserv for clinic teachers who had consumer clinics, and one of the teachers said, wow, I met with a client at our clinic last night, and she said that the Social Security Administration was listed as having made an inquiry on the credit report, and they didn't understand what that was. So now, to open up an account with the Social Security Administration, they've partnered with one of the big CRAs, Experian, to verify your identity. So I close with that just to, I guess, highlight how there's no avoiding our interaction with these three major CRAs. So, so I guess, Becky, are there any questions?
There are three so far, yes. So let's get started. So the first one is, if a husband and wife have different addresses, they're living apart, but both of their addresses are listed on the credit report for one of the spouses, does that spouse have the right to remove the other spouse's address from their report? So I guess that would be sort of, there's two parts to it. So assuming that that one spouse has moved out of what was once the marital home and they're not yet separated, it still will show in the history, but it may still also be showing as their current address. Can that spouse remove it? And then the other one, I guess, is if it's just simply wrong. Anyway, so there's the question. Perhaps I should just let the experts answer it.
Well, there's not a great answer. You can absolutely dispute that, and it should be removed if it's inaccurate. But there's not really much teeth to the consumer rights to dispute things that aren't negative credit information. So, like, you could dispute it, and it should be removed if it's inaccurate. But I'm not sure you can really do anything about it if they still don't.
Well, that's all right. Well, then how about collections that have been sold to debt buyers? Do they, the original collection, how does that 7-year rule apply to it? Does it fall off of the collection, or if it's charged off if the original debt has been sold to a debt buyer?
This is a great question because this is an extremely common violation of the FCRA. Is what debt buyers often do. They may not even know what the last pay date is, but they want to report because it's a very effective passive means of debt collection is just to report and then wait until the consumer has to clean up their credit for some reason, and the consumer will just contact you because you've reported. You don't have to actually do anything to affirmatively collect. But the rule absolutely is that if an account becomes past due and then never becomes current again, then the 7-year clock just ticks off. And just the fact that the account's been sold to some new company does not restart the clock. So debt buyers very often will either intentionally or unintentionally, perhaps unintentionally because they don't know the actual last pay date, so they don't know how to correctly report it, or intentionally because they want to do what's called re-aging. It's done often enough there's a term for it, which re-aging is just when the debt buyer reports the account as having been opened at the time that they obtained it. And then if that's the way the reporting is, the Bureau will treat the 7 years as starting then, which is wrong. It's inaccurate reporting, and it's clearly not allowed because it's all the same account. But it's a very common violation. So the answer is the 7 years absolutely ticks off from the last pay date and doesn't start over just because the account's gone to a new company. But it's a very common violation. It's something that absolutely should be disputed anytime anyone sees it.
So Matthew, so in a dispute, in your dispute letter, in the consumer's dispute letter, you want to show proof of the last payment date? Is that what you want?
Oh, and that may already be in the credit report, too. That's the thing. I mean, because or in a prior report. What you'll see often is one of two things. You'll either see a report that has two trade lines, one for the sold account reported by the creditor, which will show the last paid date, and say it was sold, and then it's separated by the debt buyer, which will be inconsistent, and so all the evidence is actually already in the possession of the CRA. Or you'll have the original creditors stop reporting, or its reporting has already fallen off because the 7 years have passed. And then you would want to, you could perhaps prove using an old credit report if you happen to still have one, but otherwise, yeah, you would have to show what the last pay date was to show that it should have already fallen off when you're disputing it.
Okay, good question. Did you have a third one, Becky?
I do. So practically speaking, whom should we tell clients to call, other than the police, if they are victims of identity theft?
I mean, what you can do for clients is download the FTC affidavit, identity theft affidavit, and have them fill it out and send it to the bureaus and furnishers.
It's just at ftc.gov.
Yeah.
I don't think I included that in the materials.
And they don't have to call anybody. They do want to try and file a police report if they can, and then attach that to the affidavit.
And there's another question now. How long are judgments left on your credit report?
So if it's never satisfied in New York, it's going to be 7 years from the date of entry. If it's satisfied, it'll fall off after 5 years from the date of the entry. So the date of entry would, that's the date, the clerk's signature or the file stamp from the county clerk, depending on what court it's from.
Okay. And then the last question, I think, can we get a copy of this presentation? Michelle, the presentation was sent out earlier today, correct?
Yes, the presentation and the materials were sent out about an hour, a little bit more than an hour before the presentation. So if you didn't receive it, please send me an email at mpeterson@empirejustice.org, and I'll email it out to you.
And I just want, this is Lauren, I want to take responsibility for moving Matthew's slides out of order, so I apologize to Matthew for that.
It's fine. As to the last question about judgments, I think it's as the person who helps out and supervising at the Claro sessions, where what we do half the time is get judgments vacated. I want to make sure everyone understands that if you get a judgment vacated, it then immediately is removed from the credit report because it's as though it had never happened.
Another question, if the debt collector won't give the consumer proof of what the debt is for, how would you resolve this dispute?
So it's reporting on the credit report, but they won't tell the consumer what it's about?
I think that's the question, yes.
Yeah. I would say this. Well, this is not a great solution. Yeah, let me think about that for a minute. I mean, you can always do a dispute and then wait until you get the response to the dispute, and then the dispute say, I've never had an account with this company, I've never heard of them, and don't know what this is. and then see what you get in response, if they reaffirm it or not. I mean, the thing I was going to say that I ended up stopping myself from saying is if you do a verification letter under the Fair Debt Collection Practices Act, then the debt collector will either give you something in writing verifying it, or will be required to stop forever collecting. And part of forever stopping collecting will be no longer reporting to the credit bureaus.
So you think that, because that's what I was wondering, if that's the best solution? So do you think
Well, the only reason I decided it wasn't the best solution is that
Yeah.
the reporting that was already done will stay on there.
Okay, yeah,
They just won't report in the future.
yeah. So dispute it. I don't know what this is, and let them come back.
Yes.
Yeah.
Follow up on that question, it just says dates of service and actual bills.
There's the question, like, what will you actually get when you ask for verification? I'm not sure what the question is.
Yeah, I'm a little unclear. I'm really sorry. Oh, yes. He just said yes.
Yeah. Usually, under the Fair Debt Collection Practices Act, they don't actually have to verify. They can just stop collecting. But if they verify, the law is unsettled as to what is sufficient verification, but usually what they send is a bill, a copy of a bill from the original creditor. So you'll then at least know who the original creditor was. You'll have a date.
Okay. Hopefully that's helpful to Sean. Okay, well, at this moment, there aren't any additional questions. Michelle, do you want to talk about the CLE code?
Yes, I did put it in the chat box for those of you that have been waiting for me to let you know what that is verbally. It's X7E is in Edward 31. So that's X7E31. And don't forget to complete the survey as well, or the evaluation survey at the end of the webinar.
So I don't see any other questions coming in. Matthew, Lauren, thank you so much for putting this together. This is extremely beneficial, I think. And it was a great presentation. Thank you so much.
Thanks for having us.
All right. Bye, everyone. Have a good afternoon.
Okay, bye-bye.